Welcome to the Explainer. Today we're going to pull back the curtain on a really important law for anyone who's buying, selling, or dealing with property in India, the Transfer of Property Act of 1882.
So are you thinking about buying your first home, selling an old apartment, or maybe even leasing some office space? Well, before you make any move, you absolutely need to know about this law from way back. We're talking over 140 years ago, and it can save you a world of headaches.
All right, here's the game plan for today. We're going to cover what this law is all about, what a transfer actually is, the 5 rules you just can't ignore, who's even allowed to do a transfer. We'll walk through a real-world mortgage example and wrap up with why all of this really matters to you.
First up, let's talk about the why. I mean, a law from 1882. Why is it still so incredibly important today?
You can think of it like a safety net. It's basically the official rulebook that keeps property deals from turning into the Wild West. It's there to make sure everything's fair and to protect everyone involved, buyers and sellers, from any shady dealings or misunderstandings.
Okay, so let's get into the nitty-gritty. The law talks about a transfer of property. That sounds pretty straightforward, right? Well, the legal definition is actually super specific. So here's the deal. According to the law, a transfer can only happen between living persons. And, this is a big one, the property has to actually exist right now. You can't say legally sell a house you're just planning to build. It has to be a real, tangible thing at the moment of the transfer. And here's where it gets interesting. When the law says living person, it doesn't just mean you and me. It actually includes companies, associations, whole groups of individuals. So a corporation can be a living person in the eyes of this law.
All right, now we're getting to the really practical stuff. This is the part you absolutely need to remember. The Act lays out 5 essential rules for any transfer to be legit. Seriously, think of this as your go-to checklist before you sign anything.
So here they are: delivery, capacity, mode, registration, and performance. These are like the 5 pillars of a solid property deal. They build on each other, and if you mess up even one of them, the whole thing could come crashing down. So let's take them one by one.
First things first, delivery of possession. This is exactly what it sounds like. The person selling or giving the property has to physically hand it over. It's about more than just a piece of paper. It's about actually giving control, like handing over the keys. This step is huge.
Rule number 2 is all about capacity to transfer. Look, not just anyone can decide to sell a property. The law says the person making the transfer has to be legally competent to do it. We'll get into exactly what that means in a bit, but it's a huge safeguard to protect everyone.
Okay, Rule 3, the mode of transfer. The how of the deal is super important. You can't just make up your own way of doing things. It has to be a legally recognized form, like a sale, a gift, a mortgage, or a lease. This keeps things clear and prevents arguments down the line.
Now for rule number 4, registration. And trust me, this one is a deal breaker. This isn't some handshake agreement. To make it official and legally binding, the documents have to be registered with the right authorities. This creates a public record, which is basically your ultimate proof of ownership.
And last but not least, Rule 5, performance of contract. A deal is a promise, right? Well, the person transferring the property has to keep all their promises. They have to follow through on every single term in the agreement. This makes sure the buyer actually gets what they paid for.
So remember how we talked about capacity to transfer? Let's circle back to that because it's super important. Who exactly does the law say is allowed to transfer property?
It's actually pretty straightforward. The law gives us a 3-point check. You have to be an adult, so at least 18. You have to be of sound mind, meaning you get what you're doing, and you can't be legally blocked from making a contract for some other reason. If you tick those 3 boxes, you're good to go.
Okay, theory is great, but let's see how this all works in the real world. We're going to use an example that most of us know pretty well: a property mortgage.
So, what exactly is a mortgage? It's not just a loan. Under this act, it's a special kind of transfer. You're not actually selling your house to the bank. Instead, you're transferring a legal interest in it to them as security. It's like saying, hey, if I don't pay you back, you have a legal claim to this property.
And this process is a perfect example of the act at work. It's a clear, step-by-step system. The borrower transfers that interest, the lender gives the loan, the borrower pays it back, and once it's all paid off, that interest is transferred back and the property is completely yours again. It's a clean process that protects everyone.
Okay, so we've gone through all the details, the rules, the definitions. So what's the big takeaway here? Why should you care about a law that's over a century old?
Well, when you boil it all down, this act is about one thing: peace of mind. It creates a clear, predictable system that protects your rights and makes sure every deal is done out in the open. It's what gives you the confidence to buy, sell, or lease property.
And it's not just me saying this. The experts are clear. Knowing the basics of this act isn't just for lawyers. For anyone dealing with property, it's absolutely essential. It's your best tool for protecting yourself and your investment.
So, now that you know the basics, the 5 key rules, who's eligible, how it all works, you're not just crossing your fingers and hoping for the best. You're heading into your next property move as an informed, empowered player who knows the rules of the game.